This is the captain, Jethro L. Bennett, creator of the Inventor's Journey, probably talking to you about deadly mistake number 4 right now. And I'm just gonna record this. Actually, I'm on the street at the moment, so there might be a bit of background noise. Hopefully it's not too bad and you can hear me okay. And this might just be a kind of supplementary audio that I'm creating, because deadly mistake number 4 is one of the hardest for me to do, because I kind of have to get multiple teachings and kind of things that some inventors might be resistant against accepting. Because some inventors have been told the wrong thing. So basically this deadly mistake, or wherever this is on the website, wherever you're finding it, this is to do with the idea that you might have been told, especially if you're an American, maybe a Canadian inventor, maybe even a UK inventor, and you've seen this online from websites, companies that are based in America, and they'll say things like, file a provisional patent application, they'll often just call it a PPA for short, to give you 12 months protection, and then you can go and try to canvass for support, kind of disclose your invention to companies. Sorry about the noise in the background. Disclose to companies to try to license your invention to. This is stratospherically dangerous. Well, it's flawed. It's a really bad way in terms of success rates. I would say this has 1 in thousands success rate if it was to be analysed. And that's not to do with how good your invention is. It's to do with how bad this is as a way of moving forward. Straight away, before I forget, just be aware, many companies will not accept disclosures from amateur inventors, kind of full stop. But many companies will not accept, the kind of companies you might want to license to will not accept disclosures from inventors merely based on them being patent pending with a provisional application, or even if you filed a non-provisional. Many of them will only accept disclosures once you have the patent granted. And they might even only accept disclosures once the patenting process from your point of view is terminated. And that's because I won't go into it in this deadly mistake because it's going to be too much information. As I said, there's a bit to go through, but it's potentially dangerous for these companies to receive disclosures from amateur inventors. You might be fine, but unfortunately there is a known psychological thing that happens with some startup inventors, especially some who maybe aren't the most trustworthy in terms of their solid thinking, where inventors get paranoid about their inventions being stolen, their products being stolen, and it can actually leave companies liable to being sued unfairly by amateur people if they allow these disclosures. So that's one of the reasons. There are other reasons as well. To be honest, there's a negative reason. Actually, I should tell you this because this is a very important thing for you to know from someone who's got a lot of experience in patenting. I drafted, filed and prosecuted around 40 plus, maybe 45 patent applications to grant at multiple different patent offices. One of the reasons why these companies probably, right, I am not one of these big companies, but I would imagine, knowing what I know about patenting, one of the reasons why these big companies may not want to accept a disclosure from an inventor like you until you've patented your invention and maybe got through and terminated the whole process, is that they might want to see how good your patent protection is, and maybe even if it's flawed, right? Because they might be able to capitalize upon this. So remember, if you're disclosing something that could be commercially important, imagine your invention is actually really good, right? Imagine it's really good, has real potential if it was executed, if the product development was done well, etc., etc. But you might have gone the normal route, before Shine came along and I told you all these things and you saw my video patenting crash course and all these kinds of things. And you may well, in fact, it's probably odds on, might have gone to a patent practitioner who maybe made fatal mistakes in terms of getting you the best, or let's say perfect patent protection. They might have got you limited patent protection in such a way that your patent that you've had granted, if we're in that situation, let's imagine, doesn't actually truly protect your invention concept. And again, I would really recommend, if you want to see an example of this, of an inventor who thought he was on the road to getting perfect patent protection, didn't realize that the patent application filed was actually going for something much more limited than he realized, then please do watch the video Patenting Crash Course. That has been maliciously removed from YouTube at the moment due to this crazy trademark situation that happened, very unfair. It might well be on the Shine Enterprise website. And by the way, if you get on the Shine Enterprise website and can't find the video Patenting Crash Course, please tell me that. What I'll do is I'll upload, I think I already have done this, but I'll upload a compressed version that is not done through YouTube so that you can watch that even if you're in America at the moment and via YouTube can't get access. Hopefully that's going to be resolved very soon. We got this malicious trademark cancelled by the USPTO, but we still, YouTube is very tough to sort these things out with. So yeah, going back to this, to give you an idea of this big company you're disclosing to, who could be $1 billion company, let's say, they might want to look at your granted patents and see whether they even need you. So they might get all the benefit of your disclosure of this potentially very important invention. So an example of that was one of my clients was a top knee surgeon. And potentially, theoretically, let's imagine, I took care of the patenting, so we're good with this one. Let's imagine he went through someone who hadn't done a very good job with the patenting. He could have disclosed this invention. After all his patenting is done and completed, he could disclose this invention to a very big corporation, $1 billion corporation, because that's how it works in pharmaceuticals, the biggest manufacturing companies. There's like a few of them and they're huge. He could disclose this game-changing technology. But if his patent attorney, either, let's say, through mistakes rather than through the fact there was prior art blocking, let's say he's made mistakes and not got great patent protection, what that means is potentially, theoretically, that inventor could effectively be giving that technology, that knowledge of that, through his disclosure to this big company. And that big company could then basically steal his invention concept without infringing his patents, if his patent protection is bad in the type of way, bad is not a technical term, but I'll use a broad term. And that might be another reason why some of these companies want to wait. They won't accept a disclosure from an inventor like you until your patenting process is completed, it's granted or maybe totally completed and terminated. Because that gives them more freedom to know what they can and can't do. They might not even need you. You might be volunteering a little bit of genius from yourself, and they might then not need you because they'll think, we can do this without infringing his or her patents. Right, so it's really a lot of problems. Firstly, you're probably not going to get to those companies to disclose. Right? You're probably not going to be able to get to the companies you want. And even if you do, there's all kinds of issues. And here's the next really big issue. And sorry, I'm going on a bit. Didn't want this to be that long, an audio, but you might like this if you really want to absorb this stuff. The next big issue is the fact that pretty much only in America do you get the 12-month grace period. Right? What this means is that in the UK and Europe, for example, pretty much everywhere apart from America, if you go public with your invention, you have immediately lost what's called novelty. You could call it newness from your point of view if you don't know the patenting terms. Basically, when you keep your invention concept private and confidential and not in the public domain, when you then go to file for that thing at the patent office, if it's the first time it's ever been done, it has what's called novelty. Novelty is one of the two main things required in order to get a patent. It's called novelty and inventive step. You also need what you're claiming to be inventive. Those are the two main things. There's one other thing, but it's not kind of as important as what we're talking about right now. Here's the thing. This is where it gets very dangerous with a provisional patent application, and this is not me just trying to scare you. I get every now and again I get a comment saying, "Hey, you're trying to scare people to buy your stuff." I'm not. I'm giving you the truth. If you want to get my stuff, it's probably a good idea for you, but I'm going to tell you the truth anyway, and this is the truth. Sorry about the noise. We've got a situation here on Kensington High Street. Actually, I'll go where it's a little bit less busy. Walk the other way back where I've come from. Okay, so I don't like the feeling, actually. I want to keep walking where I'm going. So here's the big danger, and this is a real thing. And I've had multiple cases where this has kind of happened, and sometimes it's affected cases. So this is a real thing that I've experienced even in my relatively few amounts of patent prosecutions. So what could happen? Let's give the spoon example. You'll see that in my videos. Spoon, which is a kind of serving spoon which has one or more openable and closable holes in the head to give you that added functionality if you want to keep the fluid in or get rid of the fluid out of the head. Let's imagine you file a provisional for that, and let's imagine you do it yourself. Now, it's very likely, by the way, that this type of thing will happen if you do it yourself. Even if you get my program, iPatent Pending, part of the patent pending package, it's going to be less likely that this will happen to you because I go over this in the programs, and especially you get the bonus program iPerfect Pending, which explains to you about the claim 1 of your non-provisional patent application. We try to future project, we try to future project what the claim 1 of your invention is going to be to help you to draft the perfect provisional patent application. But even then, it's still touch and go. You're not a patent practitioner, you could still make this mistake. So let's imagine your provisional. You draft it and you disclose your invention, spoon. You say something like, here's my invention. It's a metallic, it's a metal spoon that has openable and closable holes in the head. Right. And this is very, by the way, I say it happen, I'd say as standard by inventors. They make these types of mistakes. What you won't realize there is you made two potentially absolutely catastrophic mistakes in terms of that provisional actually getting you the benefit of your early filing date when you file your non-provisional. So remember, a provisional patent application gives you zero protection whatsoever. Right? Let me repeat that. Filing a provisional patent application gets you absolutely zero patent protection whatsoever. Even filing of a non-provisional, a full patent application, gets you absolutely no protection whatsoever. Let me repeat that again. Filing of a full, often called non-provisional patent application in the US, also gets you zero patent protection whatsoever. You only get patent protection once your patent is actually granted by the Patent Office. Sometimes that takes years. Obviously, with the Lightspeed Perfect Patent Service, we can get the results at Shine on the Inventor's Journey within as quick as 18 days after filing, and then potentially use that to leverage that so that you can use the patent prosecution highway to get incredibly highly accelerated search and examination at the USPTO of your US patent as well. Please look into that if you're interested in that. But you have no patent protection until your patent is granted. So inventors don't understand patenting. They think, oh, I filed a PPA, I've got patent protection. You've got nothing. You've got absolutely nothing. Now let's go back. That you filed a provisional patent application and you've said, here's my invention, it's a metal spoon that has openable and closable holes in the head. This would be quite normal for a layperson to do. However, if I'm your patent practitioner filing your non-provisional, we think you're the first person ever to have come up with spoon, this idea of, the openable, closable holes in the head, you can bet that, of course, I'm not going to limit it to having multiple openable and closable holes. I'm going to want you to get patent protection. I'm going to want to get you perfect patent protection of there being at least one openable and closable hole in the head, or you, in patenting terms, you could say a openable and closable hole in the head. In other words, at least one. I don't want to limit it to there being multiple, because then if we do that, someone can copy your invention spoon with just one openable and closable hole, and that could work pretty well. And they could then compete with you in the market because you've only got patent protection of there being multiple, more than one. Here's your problem. In the UK and Europe, well, remember, you do not have, pretty much the rest of the world, apart from America, where you do not have the 12-month grace period. When we file that claim for at least one openable and closable hole, not limiting it to multiple, the UK examiner, and I can pretty much guarantee you, because UK examiners tend to be very good, they're clever, and that makes them predictable and they're very well trained, so it makes them predictable. If they find your public disclosure, which happens, I've had this happen twice, where a UK examiner has found an American inventor's own public disclosure. So this is not just theory. They do searches everywhere. They're very good at searching. The bottom line is, we do not want to be in this situation, right? So if the UK examiner, let's say, finds the inventor's public disclosure, which of course we know is after their provisional patent application filing, so you would think, because of what you've been told, oh, I'm okay though, because I filed a provisional patent application. I've got the date before when I went public, so I'm good, right? Well, no, unfortunately, you're really not good, because the claim that says at least one openable and closable hole, the UK examiner will come back and say, unfortunately, your provisional application, I've looked through it, and it does not include disclosure of there being at least one openable, closable hole. In fact, it makes very clear in the text where you say, this is my invention, it's a metal spoon with openable and closable holes. In other words, plural. Remember, this is a legal document, it's taken at face value. So the UK examiner will say that this claim that you filed in your non-provisional is broader than your disclosure in your provisional, because your disclosure in your provisional is limited to the spoon having to have multiple, i.e. more than one. It does not include within its scope of that disclosure there being just one openable and closable hole. So he will say, for that reason, the claim in your non-provisional that I'm examining for saying at least one openable and closable hole is broader than your disclosure, and therefore does not find the benefit of priority. In other words, it does not get the early filing date of your provisional. So your provisional basically is now gone as an important factor here in terms of examination of the claim one. And you can imagine you're now in horrific trouble, because your own public disclosure, which he's also found, is now there for him as prior art, usable as prior art against your own patent application, your own public disclosure. Because remember, you've lost the benefit of priority because you didn't get the provisional right, and you don't have the added safety net that you have in the US of the 12-month grace period. Now remember, in the US, because of the 12-month grace period, this may well not be such a problem at all. But in pretty much everywhere else in the world, UK, Europe, etc., this is a real situation. This is not a scaremongering situation. This is very, very possible. And I'm sure it's happened I wouldn't be surprised if it's happened thousands and thousands of times, right? So we're not talking a very minor possibility. We're talking real. Now, if you're very scared about this, or you're anxious about it, I mean, you probably would be if you filed a provisional and gone public and you think hold on, we got a fire engine coming past. You probably would be anxious if you filed a provisional, gone public, and you actually want to patent your invention in the UK or Europe. Remember, if your focus is just America, like I said, it's much less of a concern because you've got the added safety net of the 12-month grace period. So even if your public disclosure is found, by US rules, you have up until and including 12 months from that public disclosure in order to file a patent application. If you do that and you get the date within that 12 months, and I won't go into that too much because that's got its own issues, then your public disclosure, as far as standard US PTO rules go, cannot count as prior art against you, right? So if you're really focused on US patenting, remember this, what I'm telling you now is maybe much less of a concern. But if you're trying to patent pretty much anywhere else in the world, this is a really real possibility. This is not just scaremongering, it's very real. As I told you, I've had a UK examiner twice in 2 different cases find prior art from an American inventor who put stuff online about their invention. So it's real. They will tend to find this stuff. Okay, so where were we? Okay, and that's just one mistake, by the way. There's actually, just to tell you, there's 2 mistakes here, right? So you also, let's say in your provisional, as I gave that example, you said, here's my invention, it's a metal spoon with multiple open or closable holes. So you got the first mistake of saying there's holes rather than hole and then S with a bracket. That would have solved the problem, by the way. If you put a bracket around the letter S, that would have solved the issue in the provisional. But the other issue in this example is saying that here's my invention, it's a metal spoon with ... because that limits the disclosure to metal. And of course, I wouldn't, if I was drafting your non-provisional, I don't want to limit your patent protection to metal spoons. This could be plastic. It could easily be a high quality plastic that this is made out of. So I would file a claim not limiting to metal or plastic or anything. I wouldn't even limit it to any material. And of course, that could incur exactly the same thing as I just explained happening, where the UK examiner will say your provisional is limited to metal. Now, of course, don't worry, this won't matter. If nothing, well, actually, it will matter in this case because you've done a public disclosure. If you didn't disclose publicly, it wouldn't matter, by the way, just to make this clear. Not getting the benefit of your provisional filing date or any priority document will not matter in this situation, will tend not to matter. The example I'm giving is where, let's say, an American inventor's filed a provisional, any inventor's filed a provisional and then gone public in some way with their invention, whether it's going online, whether it's disclosing in a way that's non-confidential. That's the example we're giving here. So if there was no public disclosure, then it will tend to not be a problem not getting the benefit of the provisional date, as long as there's not intervening prior art, which is the term given to when they find stuff, they find prior art, they find something that potentially blocks your claim, and it's filed in between the date of your provisional filing and your full application filing in this example. Of course, if that happens and you successfully get the date of your provisional, you will beat them to the punch. But if you lose the date of your provisional for the kind of reasons I've just gone into, then that prior art, even though it was filed after your priority document, provisional application in this case, will actually have an earlier date potentially than your later non-provisional. So there's some complexity here. It's not that scary when you just don't do stupid things, right? So hold on, there's just a bit too much noise at the moment. Okay, so going back to the metal example, again, an examiner will, if in a similar situation where you've gone public or there's intervening prior art, a UK examiner will probably come back and will say your provisional was limited in disclosure to you saying your invention, your spoon was metal. Therefore, your claim, there's a lot of noise. Hold on, let me just move off this street. Therefore, your claim, not limiting to metal, is broader than the disclosure of your provisional. Therefore, it does not find benefit. Therefore, you do not get the early filing date of your provisional. And now you might think, well, there's a slight solution to that, at least a partial solution. It's not a great one, but we could limit the claim in that non-provisional to saying that the spoon is metal, and that would then find benefit. But there could be another problem. I mean, it might be in your non-provisional, if this hadn't been communicated very well or for whatever reason, it might be that your non-provisional application does not include disclosure that the spoon may be metal. It probably would, but if it doesn't, then you won't be able to file that claim either. So you wouldn't be able to resolve this problem. Even if you did file the claim being metal and have support for that in the full non-provisional, that would only get you protection of your invention when the spoon is metal. It would not protect you when the spoon is plastic or anything other than metal. Now, for any patent practitioners listening to this, especially US ones, they will know in the US you can do something called incorporating by reference. And if that's been done in the way required, you might be able to bring the disclosure from your provisional application of the spoon being metal into the later non-provisional. But you should be aware, and a lot of US patent attorneys, for example, listening, maybe won't know this, that in many territories, well, at least in the UK, you cannot incorporate by reference. You're not allowed to do that. So there are some territories, at least, where you actually can't do that. You can't bring matter in from your priority documents into the later application. That's a little bit more of an advanced point. So if you're an inventor and don't understand that, don't worry, you probably shouldn't understand that. So, I'm probably going to bring this audio to an end. It's gone on a lot longer than I expected. The bottom line is there are real problems here. What's the solution, right? If you look at the inventor's journey, you'll see I dropped the provisional patent application step and service. It used to be in there. I'll try to flash up a graphic. If this is a video, I'll try to flash up a graphic so you can see that step used to be in there. But I realized that it really is so rarely useful, a provisional patent application. There's still the option there for that service, but it's so rarely useful that it slows down the process, it costs you money, it takes us time, etc., that it's just not in there as an essential step anymore. And so what we do in the inventor's journey, we do not disclose. Your invention will not be disclosed until we try to do invention launch, which could be licensing, crowdfunding, combination of both, could be infomercial, whatever way we're moving forward with your invention. Could be straight on Amazon, we could be trying to sell it in certain situations where it can be tooled or soft tooled for, a reasonable amount of money. So we're not going to disclose it until then. By that stage, we've gone through the whole patenting process. We've had your patent hopefully allowed or granted, and we've gone through the process, of course, by filing at the UK Patent Office first with the Lightspeed Perfect Patent Package, with the UK leg first. We get this feedback very quickly, and you might then be able to leverage those results, maybe try to then crowdfund, maybe Kickstarter. You might be able to crowdfund the money for the rest of your patenting to even pay for those types of things, or you might be able to license your invention and get that paid for you. There's all kinds of options of what ideally at least could happen. So the real solution is to let go of this idea of filing a PPA. You are now banned. I the captain, have now banned you from ever saying that you filed a provisional patent application and are protected by that, or that you've got, some inventors say, I've got a provisional patent. There's no such thing. It doesn't exist, right? There's no such thing. What they mean is they've filed a provisional application for patent and are patent pending. But as I've just explained to you, that is zero guarantee whatsoever that document, that provisional application you filed, will actually get you the early filing date for your later non-provisional patent application claim or claims. So you're banned from using that phrase, but also it might be time to just let go of this mentality of filing a PPA and then suddenly you're going to disclose and the world's going to open up to you and embrace your genius of your invention. This is just, it's got to be in the thousands to one against. It could be in the tens of thousands against. It's just a very poor quality way. It's a way forward that people go who probably have almost no understanding of invention development and probably very little understanding of product development and maybe even of things like business as well. Instead, what you're going to do is ally yourself to the inventor's journey. You're going to go through the 5 steps and the elite services in the way we need to do. We're going to get the patent search done. Then we're going to focus very heavily straight away in step 2 in designing your invention concept into the perfect design of this invention concept. And then we're going to do a basic prototype. Now, when I say basic prototype, sometimes the basic prototype can have some complexity depending on what the design of the perfect version of the product is. And when we've extrapolated all of the information from that, all of the problems that happened during the prototyping, we resolved and solved. When we got all that information, that's when we're going to file the full patent application. We're not even going to file a provisional, a standard on the inventor's journey. We're going to file the full patent application. We're going to skip the charge, the time, the money, the effort of the provisional. We're going to go for the full application once we got all that information from the perfect design and the prototype of it that helped us resolve all the problems and hopefully get to full completion of the design aspect of the invention. When we do the full application, we're then going to get the results as standard within 2 months, very, very quick at the UK Patent Office. Or when you go through Shine the Inventor's Journey, the Lightspeed Perfect Patent Service. And we're not necessarily, if let's say your claim gets allowed, your patent gets deemed allowable in the UK, we're not necessarily then going to straight away file at the US. We've got time. We've got 12 months from that filing. This is why I actually prefer it, by the way, when inventors do not have provisional applications. If an inventor comes to me with a provisional application, I'm like, oh, we got limited time now, because we're going to have to go through the patent search. Again, we're going to have to go through the step 2, the design, the prototyping. We're then going to have to get the full patent application drafted. And once we got that filed, that could have burned up quite a bit of the 12 months from that provisional application, especially if they filed the provisional application a while before coming into contact with Shines. I really don't like that. I prefer with my clients generally, if they haven't filed any provisional and they haven't got any priority documents when they come to us, because then when we file the non-provisional, we got a full, in step 3, we got a full 12 months within which to get everything done. So we're then going to try to go for we're going to do the advanced prototype for your invention, a sales-ready version to make it look and function as close as possible like a sales-ready version. This can be huge for things like Kickstarter, where you generally are not going to get anything funded unless you look like you've got a finished product ready to go to market, and people are going to fund it based on wanting to buy a unit or two maybe of your actual product. So we're going to do that, and then in step 5, final step, we're going to launch it. We're going to try to crowdfund, maybe license it, maybe go straight on Amazon in certain cases, and that's still going to be well within the 12 months of your non-provisional. So we'll see how that goes. If it goes successfully, that could fund all the rest of your patenting. Okay, so a bit longer than I want it to be. So you've probably only listened all this way if you're someone who's actually really interested in this and quite likes the fact you're getting quite dense information, and you're getting information from me, an inventor who learnt this in field. Probably information you've never got from a patent attorney before. Again, just in case you're worried, who is this guy? You probably know by now that that I've got very good information experience on this. But my academic background is comparable, superior to any patent attorney. As a former straight A student, top grade student, former scholar in ancient Greek, etc., etc. So I'm not just some chance who learnt this stuff. I was forced into a corner. I had to learn how to patent my own invention. But my academic background is, well, forget that. I would not give you information unless it comes from my own experience. So if you like this stuff, I really recommend you move forward with the Inventor's Journey as well, if you haven't already. If you're watching the 7 Deadly Mistakes and you haven't got access to Shine Enterprise yet, at least sign up for the free trial. You get more bonus stuff. Beginner's Patent Search, really good thing for you to do kind of early on in your journey, and access to quite a few other things as well. And you can just see how it goes, or just if you're ready to really start the Inventor's Journey and start the perfect patent search as step 1, sign up immediately to become a crew member and just kind of jump the queue, and we'll try to get you on that. I hope you enjoyed the audio. Sorry it's so long, but like I said, if you listen this far, it shows you're someone who kind of quite likes this information, likes learning this stuff, and I think you're going to get more of that here with Shine and the Inventor's Journey than you're going to get anywhere else, anywhere. Till the next time, this is the Captain, signing out.